So thanks a lot, Josh, for being here. I really appreciate it.
Thanks for having me, Gene. It's a pleasure.
So I have wanted to sit down with someone like you who's knowledgeable about the ITC, because I know enough about the ITC to be dangerous. So I hear really good things about the ITC from the patent owner's perspective, obviously, if you can get there, which we'll talk about. And I hear maybe some scary things about the ITC from the respondent's perspective. But when somebody first approaches you, let's say maybe we start with a patent owner. A patent owner first approaches you. They said, hey, I've heard that this is a good forum for patent owners. What do you tell them? And I'm going to ask you the same exact question about, when a respondent for the first time gets an action or investigation notice. But let's start with patent owners. Patent owner comes to you and says, hey, I want in. What do you tell them?
Well, there are a lot of good things about the ITC from the patent owner perspective. One of the main points of emphasis is that the ITC deals with patent litigation. I'm assuming we're kind of talking about a patent infringement situation, although the ITC can deal with other forms of IP as well. And in many ways, patent litigation at the ITC is very similar to district courts. You have a Markman hearing, you have infringement contentions, and invalidity plays a part. But then there are a number of things that distinguish patent-based investigations at the ITC from district court litigation that are very friendly for patent owners. So things like the speed of the investigations is a big one. District court litigation takes several years. Average times to trial, depending on what forum you're in, can be 2.5 years to 3 years. The ITC are in trial in 8 to 9 months. So that's a first pretty significant advantage. Another really significant advantage is the remedy that you can obtain. So in district court litigation, it's very difficult to obtain any kind of injunctive relief at this point in the post-eBay world. The ITC, the primary form of relief is injunctive. It's in the form of an exclusion order that the U.S. Customs enforces, or a cease and desist order, which applies to kind of U.S. sales and distribution activities. And then a third advantage that I usually highlight that in some ways relates to the speed of the investigations. ITC investigations tend to be fairly IPR proof in that the commission does not stay investigations, certainly not, as a general matter, does not stay investigations, and has never stayed an investigation based on an IPR petition or proceeding. There can be ways that IPRs can have some impact on the outcome, but for the most part, you can't kind of stop the train from rolling once it's gotten started.
So, and that's still the case. I know, because at the very, well, I shouldn't say at the very beginning, but when fintive became, like a four-letter word in some people's minds, that was certainly the way ITC was. Get to the ITC, and you kind of IPR proofed your patent. That's still the case, even though fintive has sort of receded maybe a little bit.
Yeah. So I think on the ITC side, fintive hasn't really had that much effect. The way the ITC handles IPRs has not changed at all. Really, the change is on the PTAB side of things, where there was a practice of staying or not instituting IPR proceedings because of a co-pending ITC investigation. I think there's been some change there, but on the ITC side, there's really been no effect. The ITC doesn't really pay that much attention to what's going on in the patent office. That's right.
Yeah.
That's right.
So now, would anything that you just told me differ in terms of the advantages if it was not a patent owner, if it was somebody who had a trade secret or had some kind of a trademark that maybe they're counterfeiting concerns? Are all the same? It's still just as fast. It's still.
Yeah, the IPR advantage would not be present for a trade secret-based investigation or a trademark-based investigation. There are some other advantages, though. So let's talk about trade secrets. One of the difficulties in trade secret litigation, where the defendant, the accused misappropriator, is located outside of the U.S., it's often very difficult to get discovery. That's not the case in the ITC, because the ITC is designed to deal with IP issues that have some sort of international trade dimension. There's always respondents who are located outside of the U.S. The ITC is very used to dealing with the difficulties of getting access to documents that are located in places like China or Korea or other jurisdictions in which U.S. discovery is not practiced. So that can make it very advantageous for trade secret owners to try to enforce their rights at the ITC. They'll have access to a greater quantity of information than they might be able to obtain in district court. There is a little bit of a downside, or at least something to consider, though, for trade secret owners, which is that because investigations are fast at the ITC, you just don't have as much time for discovery. So you really need to go in very aggressively, try to turn over every stone as quickly as possible, and that can put some pressure on complainants in trade secret investigations. But on balance, because of the greater access to information, it can be very worthwhile.
And in reading the ITC cases, it also seems like the judges they're not about to let themselves get played, right? If you're not going to come forward with the information at some point, they're like, okay, fine, we'll just infer everything against you, right? I mean, which is what the evidence rules are supposed to be.
Sure.
But in district court, you oftentimes see the judges bending over, and I don't know that I think it's a bad thing, but it just is. I think they try and bend over backwards to make sure that they do follow the process rules to the greatest extent and make sure everybody had all the time they needed, et cetera. The ITC seems to be, to some extent, the trains are going to run on time. We're going to get our decision done. Yeah. We're going to do our work, and we expect you to come along. And if you don't, fine, but then don't be surprised when we infer against you, right?
I think that's exactly right. So there are definitely some differences in the ITC in this issue. The ITC's kind of shibboleth about discovery is that broad discovery is acceptable in Section 337 investigations, ITC investigations. And so the ALJs are kind of looking at things from that standpoint. There is not as much of a concern about kind of proportionality as you've seen in district court over the years. Now, there are draft rules that the ITC is considering to incorporate proportionality. We'll see if that changes things. But the ALJs are kind of starting from a place of encouraging broad discovery. So that's the first thing. The second thing is that administrative litigation is different from district court litigation. The ALJ's job is to build the record. Mm-hmm. And, I think they are encouraged to build as big a record as possible so that
It seems like they almost get paid by the word. I mean, these are extraordinarily detailed, very long, very thoughtful decisions.
Yeah. The fastest way to make a district court litigator sick to their stomach is show them an ALJ's initial determination. That's several hundred pages.
300 pages is not uncommon, right?
It's not. And so you see that as well in the lengths of things like pre-hearing briefs and post-hearing briefs, which typically are in the hundreds of pages long. And a big part of the reason is you have to deal with the record, and that's several hundred documents on each side, deposition testimony, most of which comes into the record. And so it's, if you have the mindset of, well, we want a broad record, how do you get a broad record? You have broad discovery, right? Yeah. And so that's kind of the, where the ALJs are starting from. I think the third thing that affects this is that the ALJs will really come down hard on parties if they think they are withholding documents or not being above board. Particularly in trade secrets investigations, there have been a number that have resulted in sanctions, case terminating sanctions in favor of the complainant and against the respondent for things like spoliation of evidence or not complying with orders requiring forensic investigations and things like that. So even if there is a reasonable basis to think that the respondents aren't being completely forthcoming, that can be enough to create some pretty significant problems.
Well, it certainly was, and this is going back, but probably the biggest example that we could point to of that happening, probably during our entire careers, I think, because it was so bad, is the Rambis case, which my friend, and I know you know him as well, Judge Essex, Ted
Sure.
Essex, sat on the Rambis case, and they had what they called "quote unquote" shred parties. That's what Rambis called them. It's like that's a really bad fact once a judge sees that you're calling this, a shredding party to get rid of evidence.
Yes. So there have been a number of cases like that, though, at the ITC.
And why is that? Is
yeah.
it just that we learn about it at the ITC because the ALJs are really, I like to think of them as sort of like an investigator or an inquisitor, and they make decisions, but they get the record out. They want all of it there, and so that they're a little bit more attuned to when something's missing, and then we'll ask, why is that missing? It seems like it should be here, and that thread gets pulled.
Sure. I think some of it is building on the precedent. There have been, starting with Rambis, but then there have been a number of other investigations over the years, including one that I worked on involving LG and SK that resulted in case dispositive sanctions. I think part of it is there is this track record, there is this precedent of ALJs putting the parties, through the forensic investigation process, really kind of pulling at the threads and getting to the bottom of these sorts of issues. I think the pressure of discovery in a really compressed amount of time can, first of all, lead to parties acting, let's say, somewhat inappropriately, to be charitable. And then I think a third thing is because ITC investigations involve parties located outside of the United States that aren't used to U.S. litigation and U.S. discovery and U.S. document preservation issues. And often if there's a trade secrets-based investigation, the complaint is filed not that long after the misappropriation occurs. I think there's a lot of panic that can set in. And sometimes you have organizations that haven't gotten their legal departments involved yet, are not sophisticated in terms of managing their information or in complying with U.S.-style obligations to preserve evidence. I think that has led to some bad actors having a disproportionate amount of influence at
I
times.
wondered about that because, and I'm glad you pointed that out. I think panic probably is the right word.
Yeah.
When you really have that kind of panic, and particularly if you're not a lawyer and you don't understand what's going on, you don't know the ramifications of what you're doing, you could do some things that in retrospect you really like, why did I do that? Or that's just not me. I wouldn't have normally done that.
Yeah.
And that probably explains what we see at the ITC as well, because it's got to happen elsewhere.
Sure.
It's just that we don't really see it happening or learn about it happening elsewhere.
Yeah.
It's an interesting phenomenon. So before we go too much further down that path, let's circle back, and like I said, I want to do. So now I'm a respondent, and I come to you and say, hey Josh, we've never been involved in the ITC. I know people who have. They told me I got to really take this very seriously from day one. What do you advise me to do?
It's because of the speed of the investigations, it's very important to devote resources early on to responding. Investigate possible prior art. If you do want to go to the PTAB, the faster you do that, the better, because there is a little bit of a horse race that can develop between the ITC and the PTAB in terms of who gets to final determination or final written decision first, and that can play a role. developing the non-infringement theories, identifying your witnesses, identifying what are the important documents, the critical documents, starting to develop your theories. Because as a respondent, you are starting off behind the 8 ball. The complainant has all the time in the world to put their complaint together. They've, in most instances, been working on developing their theories, developing their evidence for months, and you don't have that much time to catch up at the ITC. Once a complaint's filed, an investigation is usually instituted within 30 days, and discovery starts right away. So it's really important to hit the ground running.
So can I just stop you right there for a second? Because just because I, as a patent owner, trade secret owner, or whatever, come to the ITC and file a complaint, that doesn't mean there's going to be an investigation, does it? Or does it?
It almost always does.
Oh, it does. Okay.
Almost always. Okay. There have been, a handful of cases on the margins over the years where the ITC has had some sort of problem with the complaint, that it's defective in one way or another. There have been cases in which the complaint has relied on some sort of non-patent or non-statutory IP theory of harm, and the commission has said, well, there's not really ITC authority for this particular issue. Or maybe the complainant's proof is just so lacking in some area that it doesn't pass muster at that initial stage. That's really rare.
Okay.
The ITC's governing statute, Section 337, says the ITC shall institute an investigation upon receipt of a complaint. And so it's really, it's kind of mandatory. Mm-hmm. There really has to be something just fundamentally problematic about the complaint for the commission not to institute an investigation.
Almost facially deficient.
Correct.
Type of thing? Okay.
Absolutely.
All right. That makes some sense.
Yeah.
So now you were talking about the speed and why the respondents need to take it very seriously from the get-go. What else can a respondent do, or should a respondent do at the beginning?
So I like to fight fire with fire. Be aggressive. Make a one of the first things that respondents have to do is submit a response to the complaint. It's kind of equivalent to an answer in district court. I like for my responses to be fairly comprehensive. Mm-hmm. Investigate, certainly you want to have some non-infringement arguments that are fleshed out in the response. You want to have some invalidity arguments that are fleshed out. If there are other issues, such as inequitable conduct or other equitable defenses, those are important to get in there early on, and to show the complainant that they're in for a fight, and there are a lot of issues they're going to have to contend with. If there's a kind of financial calculus that the complainant was using to decide whether to file the complaint, show them that maybe they misjudge the amount of money they're going to have to spend. And so that's something they need to consider.
So as a respondent, how often do they see the ITC being used as a battlefield in a global dispute mechanism?
Yeah, it really depends on the respondent. I think in certain industries, it's fairly commonplace. I think consumer electronics in particular, the big, there was the smartphone wars that really played out at the ITC at a particular point in time. Other kinds of consumer electronic products like laptops. I think we're starting to see things like the Google glasses and other sort of optical devices that it might be the next battlefield. We'll see how it's a little bit of a nascent technology at this point. Mm-hmm. I think as it becomes more commonplace, that could be an area where we see these sorts of global battles play out at the ITC. For other types of products, I think things like maybe more less sophisticated consumer products or life sciences products or medical devices, things like that. The ITC is not so much a a part of a larger strategy, it is the strategy. And there is a particular harm that the complainant is trying to address. One of the fact patterns we see a lot is a consumer products company who's dealing with lots of knockoff products that are on Amazon or on Walmart's e-commerce platform. And the ITC can be a very efficient way to solve that problem. But that's really a very specific, we're going to the ITC because we can solve that problem. We're not trying to deal with some sort of larger global issue.
So and I'm sure I know the answer to this, but I just want to hear you say it, because then we could kick around. So Amazon, for example, or Facebook as platforms, they're not involved in the ITC case, right? They're not a respondent, correct? So I know those are two different questions. Not involved. Maybe we get to the second.
Sure.
But the first one, they're not the respondent, right?
So Amazon has been a respondent in a number of investigations. Sometimes they are, and it's a little bit of varying flavors. So Amazon is also a consumer products company.
Right. They sell as well.
Right. Yeah. So that's part of the reason that they've been brought in as respondents. But also they are, Amazon has pretty extensive operations in the distribution of products, including counterfeit products or infringing products. Not that they're intending to do that. I'm not trying to cast any aspersions.
No, it just is. I mean, there's a lot of
that's
bad
the nature
people
of their business
that sell on Amazon.
Exactly. So if
I shouldn't say a lot. There is a component of illegality that goes on in Amazon. I think everybody knows that, and it's kind of a whack-a-mole game largely.
I think that's exactly right. I think it's somewhat baked in. I think Amazon has done things to try to deal with that problem, but it is a necessary evil somewhat for e-commerce. So, but Amazon, because of the role that they play and the nature of their business, they have fulfillment centers. They have are often maintaining inventory for some of these bad actors without realizing they're doing so. They are selling products that can be counterfeit products or accused of patent infringement, things like that. So they can get involved in ITC cases as a respondent from that standpoint. Now, the role they play in those cases is very different. They're sort of the U.S. distributor rather than the entity that's responsible for the infringement or responsible for the counterfeiting. But they have been involved in a number of investigations and have at times played a pretty significant role.
Yeah. Okay, that's interesting, and that's probably in a way that Facebook, for example, would not, because Facebook, they don't really sell; they just provide the platform.
I think that's right. That's a big distinction. Yeah.
Okay, so all right. So now there's a case that we're all waiting for, and it's the Lastrify case. And I was wondering if you could maybe tell, in some thumbnail sketch, what is that case all about? Why is it interesting? Why are people waiting for it? And then, if you have any thoughts, why is it taking so long? I mean, I thought we would have a decision in that case by now.
Yeah. So we'll start with just the very high level explanation of the case. In many ways, it sounds like it would be a prototypical ITC type story. It's Lastrify, it's a U.S. Company founded by a sole inventor whose innovation involved the artificial eyelash product segment, I suppose. And
it's like sort of in the cosmetic beauty area, right?
Yeah. So and her development of these products was very sweat of the brow. She came up with the idea herself and put in her own time, and the kind of like the inventor in the proverbial garage type of situation.
The American dream, sort of.
Yeah.
If you're an entrepreneur or inventor, it's the American story.
Absolutely. Her business was successful. It took off, and over time grew to, I think around 100 employees in the U.S., mostly involved in a kind of sales and marketing or administrative function. And let's just sort of put a pin in that.
Yeah.
Like many entrepreneurs, her her manufacturing operations are not in the U.S. They're overseas, I think in Korea in particular. And that's also an important data point. So Lashify came to the ITC, asserted its patent, identified a large number of respondents, potential infringers, and was, there was some split in the decision about infringement, but Lashify was successful in proving infringement for a number of the respondents, a number of the accused products. The issue that Lashify had was the ITC has a requirement for complainants. It's called the domestic industry requirement. What this means at a high level is that the complainant has to show that there has been significant or substantial U.S. investment in bringing the product to market or commercializing the product or developing the product that is protected by the patent, the asserted patent or the asserted trademark, whatever it is. ITC case law going back many, many years generally looks with disfavor on sales and marketing activities in connection with the domestic industry requirement. There's a kind of long-standing antipathy to complainants who rely primarily or heavily or disproportionately on sales and marketing expenditures to satisfy the domestic industry requirement. There are some cases where the commission has said, well, if you have lots of R&D expenses or you have lots of manufacturing expenses and you have some sales and marketing expenses, that's okay. We can consider those. But if the sales and marketing is really the thing, that has been a problem at the commission. That's exactly where Lashify stumbled.
So why is that? Is that simply because the ITC was grew up during a time when it was about union jobs, union workers, people manufacturing in manufacturing facilities, and that's what it was really, or that's what the folks saw as really they were trying to protect and save, or is there something else?
Yeah, I think that there is a healthy dose of protectionism with the ITC. The notion of the ITC and why it plays a role in the IP space at all is essentially this sort of protectionist thing. We want to incentivize U.S. investment in things like production or manufacturing, things that will create American jobs and support the economy that way. That's one side of the coin of the ITC, of the logic of it. Getting rid of counterfeit products from abroad is another part of it. But in connection with that, there is a notion of rewarding U.S. investment. If we look at the evolution of Section 337, there was a time where it was really looked at as manufacturing was the only thing that counted. Maybe research and development to an extent, but it was really based on having smokestacks. And there was an amendment in 1988 of Section 337 that expanded the categories of investment that could be considered. So adding things like R&D expressly, licensing activities were incorporated. So things that would exploit the IP right that were not necessarily limited to production. But it's really funny that Congress takes some act and maybe the intent is to push things one way, but there's a lot of inertia. And the ITC is an administrative agency. It's the same people who tend to stay in the general counsel's office for a long time or tend to stay as ALJs for a long time. And so I think there is a lot of, I think the way this actually played out after the 1988 amendments was, the gravity sort of took hold and things fell back to earth a little bit. And maybe that resulted in the evolution of the case law focusing on things that were more like production, more like manufacturing, even though the commission didn't limit just to that kind of activity. Sales and marketing in particular, there's a little bit of, I would say, ambiguous language in the legislative history related to the 1988 amendments. And the language is along the lines of We're not trying to say that any mere importer can come to the ITC and get this relief and satisfy the domestic injury requirement. Sales and marketing by itself would not be enough. And I think sales and marketing by itself would not be enough has sort of mushroomed over the years to sales and marketing can't be considered at all ever. And there is a split within the ITC and among the commissioners about when sales and marketing expenditures can be considered. Can they ever be considered? And we'll see how that plays out in Lashify. That Lashify is kind of the perfect test case for dealing with that issue.
So that issue is queued up for decision.
It is. It is front and center in Lashify's appeal.
And the court being the Federal Circuit, right?
That's right.
Whether they actually decide that issue, we'll have to wait and see. But that's what everybody's hoping will be decided one way or another, I guess.
I think that's right. I think that's right. And there's a lot of sympathy for Lashify. It has this, as you said, kind of American dream quality to it. It would.
I've shared this with you. What bothers me about this is between the difference between what Lashify did and what Apple does. Mm. I mean, there's differences, but I find them personally to be slight, in the order of magnitude, certainly, right? Mm. But somewhere along the way, the owner of this company figured out how to do this here in the U.S., came up with the product line, now has 100 people. They manufacture overseas and they sell here. Well, Apple manufactures overseas and they sell here. The difference is, I suppose, is they do an awful lot of research and development here. And not exclusively here. They have a big facility over in Ireland and probably elsewhere around the world. But that is really the research and development aspect is what would separate an Apple from a Lashify, right?
I think that's exactly right. Apple's certainly an example you could use. I think there are examples at the ITC where the complainant looks more like Lashify, but does have some ongoing R&D, and that has been enough to pass muster in terms of the domestic industry requirement. In fact, there's a recent commission opinion that was just issued in the 1355 investigation. Ridge is the complainant. I know a company that has been at IP Watchdog in the past.
And they're going to be at Live as well. And actually, we're having a women's forum here in a couple of weeks. We'll have the chief IP counsel will be at that, and then the general counsel will be at Live. Yeah, they've been very aggressive. Mm-hmm. Well, they have to be because it's so easy to knock off what they do.
Absolutely. So and they came to the ITC. They got a good result, and really they have a very similar story to tell as Lashify. It's a kind of company that was founded by a father and son. The son was the inventor, is named on the patent, successful in growing the business, dealing with lots of knockoffs on Amazon and other e-commerce platforms. The difference between the Ridge example and Lashify is, I think, in Ridge's case, there ongoing R&D activities that they were able to point to and able to say, well, we have these 5 engineers who have been working on expanding our product line and improving our technology and so forth. And Lashify really wasn't able to point to that kind of ongoing development work. So if you want to draw a distinction between the two, if you want to say, well, the Lashify story superficially sounds great, but it's also, somebody did work to develop this patent and develop this technology many years ago. They're not doing anything to kind of reinvest. And so maybe it's not as attractive a story for the ITC as a Ridge, for example.
Was, yeah. No, and I get all that. I just find it frustrating because it seems to me that at its core, what the ITC is all about, all it's intended to do is not all it's, maybe, it fundamentally founded to promote U.S. jobs. Mm-hmm. And I don't think it's any exaggeration to say that if Lashify loses, they're going to go out of business. And we've seen that with other companies like Elashify, where they start getting competition from overseas, and it's not usually counterfeit because they find that as long as I can make your product, if I put your logo on it, that's a whole other level of pain and problem with customs and everything. So they just knock you off, and they with how easy it is to send products all over the world by ones and twos, you don't need to send them in a container ship. You can for sure, but
Sure.
I think that we've seen a number of companies lose out that have been getting knocked off by overseas competitors, and those American jobs go away. And I would like to see a little bit more focus maybe on the jobs aspect of it. And as long as they're bona fide jobs. I mean, because there's things that obviously shouldn't count, I don't think. But
yeah. Well, I think that's a really good point. I think the question is, I agree, the focus is in part on jobs. I mean, labor usually is a complainant's biggest source of domestic industry expenditures, plays an outsized role in ITC investigations. So it's certainly something that the commission is very focused on. But I think there's a more subtle question, which is what types of jobs do we want to encourage? Do we want to encourage any job, including a sales job or a marketing job, something that is kind of fairly fungible, not to offend any of my colleagues who work on sales or marketing. No,
I mean, I think that's fair. It's a skill set, right? To be able to sell is a skill.
Absolutely.
And if you could sell one thing, you could sell another thing.
Sure. But there's also this question of do we want to encourage any job, or do we want to encourage manufacturing jobs? Do we want to encourage engineering jobs or development jobs? Things that maybe, I don't know what the policy distinction is between these different types of jobs, but I think there is one, and that's kind of what has undergirded the ITC's jurisprudence over the years, and what is you can kind of see play out in the legislative history for the 1988 amendments and so forth.
Mm-hmm. Yeah. It's an interesting. I mean, obviously, I say obviously, but maybe we should kick this around. But if you're the patent owner, certainly if you're a patent owner, but with trademarks or trade secrets as well, the ITC injunctive relief, which is in the form of cease and desist or exclusion orders, is extremely palatable. Now you could get injunctions probably for trade secret misappropriation. You could probably get it for counterfeiting. Where it falls apart for a lot of patent owners is on the patent side.
Sure. Since
eBay, can you tell us a little bit about how it is that the ITC can exist without applying eBay?
Sure. So eBay deals with the standard for injunctive relief that courts apply. The ITC statute, Section 337, is expressly directed to exclusionary relief, injunctive relief, cease and desist orders, exclusion orders, and so forth. So Congress has effectively decided this is the commission's authority, and there's nothing written in the statute that suggests that there should be some wiggle room of not issuing an exclusion order if a violation of Section 337 is found. Quite the opposite. The commission looks at their job as, well, an exclusion order is our default remedy anytime a violation has been proven. For different kinds of injunctive relief that the ITC can issue, for example, cease and desist orders, it's a little bit different. The commission has some discretion in terms of whether to issue a cease and desist order or not, and that's an issue that's heavily litigated in 337 investigations. There is a form of exclusion order called a general exclusion order that applies to non-parties to the investigation, and there are criteria that the ITC uses to decide whether to issue a general exclusion order. But for a kind of standard run-of-the-mill limited exclusion order that's going to apply to the parties to the investigation and no one else, it's default. And maybe the commission can tinker with it a little bit, but you're going to get an exclusion order as a patent owner if you prove that there has been an infringement.
So it really boils down to just as simple as there's a different statutory framework that applies to the ITC injunctive relief versus the patent injunctive relief in district court.
That's right. That's right.
And eBay applied to the district court and the patent statute, not the ITC statute.
Correct.
Yeah. So so that's why a lot of folks would really like to be able to get to the ITC if they can, although it's not cheap, right? I mean, with the speed and the overwhelming amount of evidence you need to have at the get-go, or if you're the respondent that you need to get going the minute you get complaint, it's not probably as expensive as an all drawn-out patent litigation in district court, but it happens over such a short period of time, and it is pretty expensive, right?
Yep. It is. It is. The way I usually will explain this as an ITC investigation can be as expensive as a drawn-out patent litigation in district court. Maybe you get a little bit of a haircut because there's just not time to do everything that you might do in district court. But the run rate is going to be a lot higher, maybe 2x, maybe higher than 2x.
Yeah.
Yeah.
Yeah. So you got to be all in, or it's not somewhere where you go.
That's right. And there's no ramp-up time, really. Yeah. You have to start incurring costs almost immediately. There's not the 90 days after you've been served with a complaint or after a complaint has been filed while you're waiting to get served, or the time that you can negotiate to extend your answer deadline, or the time that the district court is going to take to schedule a Rule 16 conference or something like that. Where you have 6 months in district court patent litigation before things really get going.
Right.
You don't have that in the ITC.
No. You're halfway done by that point.
Yeah.
Yeah. Well, I guess where we can go now, just shifting gears a little bit, is so you as the IP owner have now gotten some form of injunctive relief. Let's say it's an exclusion order, because that's the most common, right? So you have an exclusion order. It seems to me that this was news to me when I heard this recently. It's like, okay, so the game is now afoot. So the respondent has lost. It's like, well, what do you mean the game is afoot? The respondent has lost. But there is an awful lot of time and energy that goes into while these cases are ongoing, respondents figuring out workarounds and then being able to come forward and say, hey, yeah, maybe what you said was right, but that's not what today is. Here's what we have today, and it doesn't infringe.
Yeah. That's
but there's
right.
a process that has to go through, right? Because is it the ALJ that has to take a look at that and say, okay, yes or no, it really is a design around, or how does that all play out?
Yeah, so for design arounds in particular, there are a few different ways that it can play out. From a respondent's perspective, ideally, you develop the design around quickly enough that you can produce a prototype that can then be imported into the U.S. You provide access to that import so it can be inspected during discovery, documentation that explains how it works, and contentions that explain why it doesn't infringe the patent. And this is all done in that 4 to 6 month fact discovery period, so that the ALJ can consider the design around and issue findings of non-infringement, ideally, on the design around. When that happens, then if there is a finding of violation as opposed to the previous products, the earlier generations, there can still be a kind of a carve-out in the exclusion order that applies to the design around. So even if the respondent is not able to import the older products, it still has a way of getting its new redesigned products into the U.S. And the commission will include a certification provision in its exclusion order so that when the respondent is importing the redesigned product, it can certify to customs, these products are not infringing, they're not subject to the exclusion order, they're allowed to enter the country. So it can be, it's very smooth for the respondent when that all works out. It can be difficult to get that to work out because...
Well, just the timing.
Exactly. Right? That's the main thing. The main thing. It can be, and you're doing that, you're redesigning a product while there's still not clarity as to how the claims will be construed.
Or if you were infringing in the first place.
Indeed.
So let me ask you with respect to that, like, so let's say that the respondent doesn't get all that together in the 6 months or so that they have, but by the time that the exclusion order is issued and then the commission has decided either to let it stand or maybe review like a couple of the findings here and there, and then it all starts to wrap up, what if they are not infringing at that point in time? Is there like a declaratory judgment that you can file at the ITC, or would you move it to district court to get a declaratory judgment like that, or how does that process work?
So there are a few routes. So first of all, the respondent can go back to the ITC, can petition for a modification of or rescission of the exclusion order, or can request an advisory decision from the ITC. This is another distinction between district court and the ITC. The ITC can issue advisory opinions on infringement. So there's this opportunity, if there are kind of post investigation developments or post final determination developments, or even post ID developments, to go back to the ITC to get a ruling on the redesigned product. Problems with that is that it can take time. While these other proceedings are pending, you're subject to the exclusion order. So there is an impact that is felt at that point. Another route is to go directly to customs and request a ruling under Part 177, which it's essentially a kind of abbreviated infringement determination, where it's almost like a summary judgment motion, where the petitioner will submit a ruling request to customs. The IP owner will respond. There often is a live hearing. It's a few hours. It's kind of like a summary judgment argument. And then customs will issue, their IP division will issue a ruling as to whether the product at issue is covered by the exclusion order because it's infringing or exempted from it because it's not.
Mm-hmm. Is there a preferred path to go to, or does it really just depend on where you find yourself?
It kind of depends on where you find yourself. I mean, yeah, if you're not in that ideal world where you've gotten the design around done quickly and you've gotten the ALJ to rule on it during the investigation, the other options are not great alternatives, but you have to kind of make the best of what's available. I think the Part 177 customs proceeding is a fairly attractive option. It is fast.
It's not appealable either, is it?
It can be.
Or is that sort of up in the air at the moment?
It's a little up in the air, but it can be in a sense repealed to the Court of International Trade. Mm-hmm. What usually happens, though, is when customs issues a ruling that's adverse to the patent owner, the patent owner goes back to the ITC and files a complaint for an enforcement proceeding. So the ITC ultimately can overrule the customs decision.
Okay.
It's like an appeal, even though it's not a direct appeal.
Sort of like a collateral attack that winds up challenging what customs did.
That's a good way to describe it. Yeah.
Okay. So, there's a lot of moving pieces and parts here. And the one thing that we haven't talked about that at any point in time during this process, the respondent could settle with the patent owner.
Yep.
Right. How often does that happen? And maybe while you're thinking about that is are we dealing primarily with patent owners? And I know this is not exclusively, because I don't think Ridge would fall into, but patent owners who just want to get paid and are maybe not as they don't need you're infringing, you're causing me a market, I want to get paid, and if you want to license it, I'm fine to license it. I don't think that's what Ridge wants to sell.
That's right.
And they have the capacity to sell. So can you give us an idea of like how often do you get one type of owner versus the other type of owner?
Yeah.
And how often do these things settle?
Sure. So it varies a little bit over the years. There are different flavors of ITC cases. The Ridge example, where it's a kind of, really about the market and clearing the counterfeit products out of the market. I haven't looked exactly at the numbers. I would guess that's probably maybe a third of the ITC's docket. And the rest is some combination of competitor to competitor patent litigation, where the patent owner really does think the other side's infringing and either wants to get the product off the market to get a competitive advantage, or maybe would accept some sort of settlement where there is a royalty being paid, right? And then there is some there is a portion of ITC investigations where it is about the money. And the exclusion order is the lever that will exact a higher settlement.
Okay. And so about how often do these cases wind up settling? They settle pretty regular, don't they?
They do. Yeah. They do. I mean, like any litigation, ITC investigations tend to settle. I think not as high a rate as in district court, where it's, I haven't looked at the numbers lately, but it's say over 90% of cases will settle. I think the ITC is well below that. And a big part of the reason for that is there's not time. There's just not time to really evaluate settlement in the same way that you would in district court. There are also not as many kind of outs in an ITC investigation as in a district court litigation, because things are happening so fast. You have a Markman hearing. It's usually maybe 3 or 4 months into the investigation. And, in district court, the Markman order will give the parties a pretty good idea of where they stand. In the ITC, the Markman order is coming so late, sometimes it's like you don't get it until after trial, essentially. So that is, I would say, put some downward pressure on settlement.
Well, it also seems to me that, like whether you're the owner or the respondent, complainant or respondent, if you go to the ITC and it goes beyond like the entree, the initial salvos, you've come to terms with, okay, I know about how much money I'm going to have to spend.
Right.
I know about how quickly I'm going to have to spend it. And you either are all in or you're not. You're either looking for the door at that point, or you're like, okay, well, let's fight it. Whereas in district court, sometimes when these things go 3 or 4 years just to get to the conclusion of the district court trial, somewhere along the way, your CFO might say, oh my God, there's another bill from the litigator. Right. Oh, there's another bill from the litigator. Right. And that then offers not only on the legal timetable or schedule based on procedural stuff, there's what happens quarter to quarter when the CFO is looking at the numbers.
I think that's a great point. You really have to budget for an ITC investigation all at once, because most of the spend is going to be in the lead up to trial. Trial is going to happen within a year, in basically every investigation. That there are a couple different ramifications of that. There is the kind of notion of being pot committed. If you've budgeted this amount of money, it's really hard to walk away, even if you start to get the bad feels about your case. There's also that aspect of what is the quality of information that the ITC counsel is giving to in-house counsel, or given if there is in-house counsel, or given to the client's decision makers. Especially since there's just not a lot of information to go on because of the fact that you're not necessarily getting a Markman order that addresses every issue, or maybe not any issue. You're not. There's no summary judgment, basically. There are no early case motion, dispositive motions. So you don't have a lot of information to go on. You may start to think things have taken a turn for the worse, but without a lot of data points, it's hard to give your client like good certainty about, well, we really should settle at this point.
So, and let me ask you this. So, how much percentage-wise, generally speaking, you don't have to give me hard numbers, but because this is probably going to vary depending upon how much is involved, right? But how much of a percentage of the overall budget needs to be earmarked towards an appeal? And the reason I raise that as an issue is because one thing that I've seen in, maybe not recently, because I think district court litigation has kind of gotten really out of whack between the PTAB and Alice and Mayo and a number of other things, eBay. I think it's kind of shuffled the chairs a bit. But when I first started my career, and it was more I guess you could say predictable, people would think that they should have won, and they're like, well, I've already got this much in. The Federal Circuit appeal is going to be sort of a rounding error compared to usually how much you have already invested. So I lost, I might as well give it a go. I mean, how much of that factors into the decision not to settle, do you think, and to continue even after loss? Because after a loss, there are potentially consequences, but it seems to me, just an observing, and I know I'm laying a lot out here, but it seems to me in observing, lately, the Federal Circuit has been very willing to say, okay, no on the exclusion order until we've had our chance to look at this. Is that fair? And two, how does all of that dynamic factor into settling versus just going to the Federal Circuit?
Yeah, sure. So a few things. So first of all, your sense of the economics of it, I don't think have changed. Compared to the cost for the investigation, the appeal is still somewhat of a rounding error. I mean, maybe like 10% of the budget is a good rule of thumb. Yeah.
Okay.
So, if you've gone through the whole investigation, paying for the appeal really isn't a deterrence, and I don't think it's a driver of settlement. I think what happens instead, though, is, first of all, it depends who lost. If it's the respondent, well, then they're looking at an exclusion order. Right. And that can be a really good reason to settle at that point. And the cost, the impact from the exclusion order financially is going to be far more significant than the cost of an appeal if there's not a design around. If there is a design around, however, the cost of losing may be, nil, essentially. So that plays a role as well, and maybe that's a reason for the complainant to settle at that point, right?
But for example, just recently, I think I've seen, and I don't think that this case has reached a final decision yet, but didn't weren't they able to get out from under an exclusion order with the Massimo, and the Federal Circuit said, okay, well, no exclusion order until we've had a chance to look at this? And is that because, I don't want to say it's, because I don't want to imply anybody's on the take, because I don't think that's what. But when you have companies like Apple who do employ so many people in the U.S., and that would be an enormous order.
It would.
Does that factor in to them? And how often does the Federal Circuit say, we're going to call a timeout?
Almost never.
Almost never.
Almost never.
So that was sort of a one-off.
I think that's right. Unusual circumstance. I think in the Apple Massimo instance, that's also an example where Apple did go to Customs and requested a Part 177 ruling, and it took maybe longer than normal, but they ultimately were successful in getting a ruling for their design around, which was, in terms of design arounds, I think it was essentially like we stripped out the accused feature. Right. And so, you could look at it from Massimo's standpoint. Well, isn't that kind of what you want? You don't want other people to use your IP. Right. They achieved that objective, right? But it's really rare for the Federal Circuit not to Federal Circuit to stay an exclusion order, even if there is an appeal.
So, to give us an idea, when the presidential review, when the president steps in, that's like a once every other generation kind of a thing.
Yeah.
How often does the federal? It's probably not that much, but is it like once a year, once every other year, once every 5 years, or?
Oh,
I mean, do you have a sense? And if you don't, that's fine.
Yeah, well, I can say it this way. I don't know of another instance in which the Federal Circuit has stayed an exclusion order.
So that's a unicorn as
it
well.
Is.
Okay.
It is. Yeah.
Interesting. Okay, and that maybe says something about which way that case might ultimately go, and particularly if Apple did get a workaround order.
Yeah.
Anyway, this is just so fascinating. I mean, when you're dealing with the ITC, it feels always to me like you're playing a game of three-dimensional chess.
Yeah.
And literally with the clock, where the clock's running, you got to stop the clock. So say,
right.
Only that clock doesn't stop. Just because you move doesn't mean the clock stops. But that's really what's going on, right? I mean,
yeah, 100%. Yeah, there are so many things that you have to keep in mind. Things about, there's all the normal patent litigation stuff or the IP litigation stuff in terms of proving your case. And, if you're on the respondent side, showing you don't infringe, showing that the patent's invalid, and that whole thing. And then there's the thought of there's the domestic industry issue, and there are all these financial considerations that come into play. There are issues about the potential remedies and dealing with those. There's a redesign that you want to hopefully develop and litigate in time. And then there are, at different phases of the investigation, public interest considerations that come into play. There are looking down the road, if we do get an exclusion order, how are we going to comply? What is our strategy going to be for minimizing the impact of it? What are we going to tell our business partners about their potential risks if they can't get supply from us? And then you are making these decisions, lickety split. So it's a great analogy.
You got a great smile on your face. I can tell you really enjoy this, right?
I do. I do.
It seems like it's a lot of fun. I mean, it's got to be stressful for the parties that are involved. But it probably also has to be quite cathartic too.
Sure. It is. I mean, look, there are people who love speed chess, right?
Right.
And the excitement of it, the fact that you do have to deal with all of these different issues and keep all the balls in the air, while considering your client's business and considering how it's impacting them, and to considering just the impact of the investigation on their daily lives and how they are facing the disruptions and trying to minimize those things. And then you're in the knife fight with the other side at the same time. I mean, there's a lot of the endorphins flow. It's an exciting way to make a living.
Well, good. I really appreciate you being here. I think this was a fascinating conversation. Is there any last thought that you have for somebody who maybe has been thinking about trying to use the ITC, or somebody who just for the first time has gotten a complaint? What is your words of wisdom?
It's kind of knowledge is power. The more you can educate yourself on the peculiarities of ITC litigation, the better position you will be in, the smarter decisions you'll make, including the decision of whether it makes sense to be at the ITC, whether it makes sense to fight. Maybe there is some early off-ramp that you can find that is not readily apparent. But if you educate yourself, your strategic options will increase.
Great. That's awesome. Thanks so much, Josh. I really appreciate it.
Thanks, Gene. It's been a pleasure.